Okay, so a very good evening, everyone. A warm welcome to this important and insightful webinar on jurisdictional challenges in cybercrime prosecution. This webinar is brought to you by Naksh Foundation under its flagship initiative, Project CyberShield, as part of Cyber Awareness Week. Cyber Awareness Week is a week-long mission all about making the digital world a safer place for everyone. In an age where cyber threats lurk around every corner, awareness is our greatest defense. Through this campaign, we are here to educate, empower, and equip you with the knowledge to navigate the internet safely. I'm Kirti Chaudhary, and along with my co host Aditya, it's an honor to be your host for today. Before we start, I want to state that this session is being streamed live on YouTube, and for those who are unable to join via Google Meet, you can easily participate by following the YouTube link provided. Before we begin, participants, we request you to keep your microphone on mute throughout the session to avoid any background noise. And it is also a request to keep your video on. It will be highly appreciated. And if you have any questions or queries, please drop them in the chat box. We will address them during the Q&A session. And participants kindly note that it is mandatory for all to fill out the feedback form, which will be shared 10 minutes before the end of the session. And it is important to be filled to be eligible for the participation certificate. More about the session. Is there any text? Sorry for the interruption. Cybercrime, due to its borderless nature, presents significant challenges when it comes to jurisdictional issues in prosecution. Unlike traditional crimes that are typically tied to a specific location, such as physical crime scene, cybercrime can occur across multiple jurisdictions simultaneously, as they involve the use of internet, which transcends national borders. This complexity often creates legal hurdles in identifying the appropriate forum for prosecution, determining which country's law should apply, and addressing cross border cooperation among law enforcement agencies. To discuss this topic in more detail, we have a very distinguished guest with us today, Professor Dr. Anjali Tomar. She, with her 18 years of teaching experience in law, is a distinguished academic and researcher. She has authored 9 books and over 5 Scopus Index articles, and she is also the editor of GNLU Review. Dr. Tomar is a recipient of 5 gold medals in LLB honors and LLM from DAVV Indore. She has also been awarded a PhD in criminal law in 2010. She contributed to numerous government projects and a research initiative, trained central and state government officers, and successfully guided 4 PhD students. With expertise in criminal law, information technology law, biotechnology law, and taxation law, Dr. Tomar has also led a research center at GNLU and served as the head of academic affairs from April 2022 to March 2024. Without further ado, I would like to hand over the floor to you, ma'am, for your insights on this topic. Over to you, ma'am.
Thank you, Kirti. Thanks a lot. A very good evening to one and all present. First of all, I am very thankful to the organizers, Naksh Foundation, who have organized this cyber awareness program and have also given me this chance to share my knowledge and my understanding, the very little knowledge that I have on the subject with all of you. As Kirti was telling, that you can also put the questions in the question and answer in the chat box. I would also like to say that if there is anything pertinent, anything which you would like to ask in between as to my content, you can definitely raise your hand and I will be happy to answer. But would appreciate that if the questions can be asked in case if there is very important question, you can definitely ask in between. But if a question can wait, please drop the question in the question answer session and I will try to answer it. So let's talk about what exactly is the I have to share the okay. So I wanted to share this presentation. I hope it is visible to everyone.
Yes, ma'am, it is visible.
Fine. So we are going to discuss. Uh, I would like to discuss with you this slide. When I'm changing the slide, it is being changed or not? I am unable to change the slide.
Uh,
Kirti, can you see
it's on
that
the
it is being?
first. Ma'am, it is on the first slide only. If you
Okay,
would have changed.
just a minute. Just a minute. I'll again try. I will. I think I have to open it with the entire window. So I'll just one. I would request the audience to please wait. I'll just check if it is possible for me to open. Am I having the presentation rights with me? Kirti, if you can please check whether I am having the presentation rights.
Yes, ma'am. Just give me a minute.
Yes, ma'am, you have.
So I'll again check it. I'll open it on my screen and I'll try to share.
It's still not changing if you're.
Is my screen being shared?
Not right now.
Can you see it now? Is it changing, Kirti?
Yes, ma'am. Yes, ma'am. It's
Okay,
changing.
fine. I think there is understanding issue from my side only. So now is it visible to everyone? Kirti, if you can please let me know.
Yes, ma'am. It's visible.
So let us. I am very sorry. See, this is the live demonstration of how cyberspace is, and there are so many issues. Not only jurisdictional issues that we are going to discuss and talk, but there are so many other aspects, technicalities which are involved in the cyberspace. But my discussion would be more to let you understand that what exactly do we understand by jurisdiction and why do we need to discuss it. See, when we talk about cyberspace means it is something which is a fourth dimension to something that we are talking about. And if I will just take the help of what exactly has been academically explained, so we can say that it's an interdependent network where a number of data is being exchanged. We find that it includes internet, it includes telecommunication network, computer system, and whatnot, and what all. So this particular aspect of cyberspace has been something that what not existing earlier. It was not been something that has been thought of, but it has actually been coined from a fiction. So cyberspace, cyber word has come from a fictional state that was being raised, that has been coined in some 1940s. But today we find that cyberspace is a reality, and we have a number of issues that we need to discuss. And I think the August gathering is aware of the fact that it is ever growing as well. We are not being aware. Maybe we are talking about something at this point of time, and cyberspace might have got to some other issue as well. So when we talk about cyberspace per se, it's a very broad term. It's not limited to what I'm telling you. It is something far beyond it. It is inclusive. This definition is not independent and not exhaustive. So we see that cyberspace is also a term that has been used to discuss about what is computers, network, software, data, all those things which are a part and parcel of our daily life, and it includes all the electronic devices as well. So suppose if we are sitting over here, and there is a device which is working in this room, which is letting understand that what should be the temperature of the air condition, and air conditioner that is being operated, that also is something which is operated on a cyberspace. So in fact, when we talk about cyberspace, as I stated to you, the definition that we have today, it is not exhaustive, but it is inclusive of so many aspects. So when we are talking about what exactly is cyber crimes, and how the cyber crimes would affect the jurisdiction issue or the disputes, so the what normally happen, I'm a student of law of crime, so I am more concerned with to let you know about or to discuss with you the concept of cyber crimes per se. But in fact, when we talk about jurisdiction, it is not only limited to cyber crimes. But since our discussion is basically on cyber crimes, we say that it can be broadly categorization. There are a number of categorization possible of the way that this jurisdiction issue has to be discussed per se when we are talking about cybercrime. And I must tell you that when I was researching before coming to the class, I found more than 10 such articles that have given different way of categorization of the cyber crimes. But for the sake of the basic understanding of the subject, I am just dealing with these two type of cyber crimes, where we are talking about the traditional type of crimes that are being conducted or that are operated through computers, or the second type of crime where computer itself is the mean mode or the ultimate objective for the for a crime to be conducted, to be committed. So we find that basically we are discussing for Indian Penal Code, which is now been renamed as Bharatiya Nyaya Sanhita 2023, and Information and Technology Act 2000, which is soon going to be Digital India Act. We are still waiting for the president's permission on for this. But for the time being, we are going to discuss, since Digital India Act is still not a reality, we will discuss about what are the provisions of Information and Technology Act, and how Indian Penal Code, which is now BNS, is talking about the cybercrime. So let us understand that how cybercrimes are being tackled, or what exactly is the framework for understanding cybercrime. Many times we see that a number of things happen with us or people around us, but we are not aware exactly what is the law that we should look for. Whether this is something which is an infringement of my fundamental right, my human right, my right which is given in the humanitarian law, or something which is given in the penal law, something which is given in the civil law. So let us understand what are the provisions of Information and Technology Act 2000. We are talking about this five different types of crimes which happens in the cyberspace, inclusive of damaging to the computers, which is talking in, which has been given or reflected in section 43 of the ITA. Data theft and hacking, which is referred in section 66B to section 66D. Cyber terrorism is a new provision which is penalized under section 66E. And now, for the audience, that the terrorism has also been included under section 113 of the BNS, which was not originally there in the IPC. So we are talking of cyber terrorism as a part of ITA, and terrorism as a part which is there in the BNS as well. And BNS is also reflecting to an extent that terrorism can also be caused through computers. So in fact, we are talking of the BNS and ITA together that talks about the cyber terrorism. As far
Excuse me,
as,
ma'am. Sorry for the
yeah,
interruption. Are you changing the slides?
the slides are not being changed.
No,
Can you
ma'am.
see the slide changing now?
No, ma'am. It's on the first slide only. The second slide is visible.
I think this is what I have opened initially, but I am unable to change it. I am unable to change through this. When I go to the presentation itself, can you see now? Do you
Yes,
see the
ma'am.
change?
It's on third slide now.
Yeah. Now, do you see the fourth slide?
Yes, ma'am.
Okay. So this is what I was talking about. Is that anywhere in between, na, Kriti, if you Kirti, if you don't see my slide changing, just remind me, and I will again check whether it has been possible or not. So I was talking about cyber terrorism. So this is what the section 43, section 66 to B to section 66D, and obscenity is what we are talking about under section 67 of the IT Act. And I would like to inform that section 292 of IPC is also talking about obscenity when it comes to like in the form where the it is represented in two dimensions. So when 67 is there, if that particular thing is being reflected through electronic means, then section 67 of the ITA will come. Child pornography has been also mentioned in the ITA under section 66B of the ITA. Now, let us talk about the very specific topic that we have to discuss today is about the jurisdiction. What exactly is jurisdiction that we look at? So when we see that and why do we need to discuss it? Like jurisdiction, it's like say suppose if a crime has been committed electronically with my client who is sitting in Calcutta, there should be absolutely no issues related to the jurisdiction. It can be tried in India. But what if my client is Japanese, sitting in Calcutta, got some sort of a victim of a cyber crime that has happened somewhere from Nigeria? So here the question is whether Nigerian law should prevail, Indian law should prevail, or Japanese law should prevail, because we see that there are three different states have been involved. So in fact, when we talk about the jurisdiction per se, it says that it is something which is every kind of judicial action that can be take that can takes place in where in such a situation where the court of that respective state or that respective nation can take the cognizance of the matter. So, for those who are not very well versed with the legal terms, cognizance is a term that we normally use where court is empowered to try or to discuss that particular matter within its jurisdiction.
Ma'am, please wait. Your voice suddenly, you're not audible. No, ma'am.
Am I audible now?
Yes, ma'am, you are.
Okay. Seems that there is a issue.
Ma'am, you again, you are not audible at all.
Am I audible now?
Yes, ma'am.
So please just let me know if it is not been audible to you. I don't know what is happening. This is technology, and this is where the technology comes into a lot of issues, isn't it? That we have to discuss. It's not only the cyberspace that is causing issues. We also see that the connectivity is also one of the concern. right? So when we are discussing about the matters which is related to the jurisdiction, there are a number of things which we have to take care. This aspect of the jurisdiction is something that we discuss at the end, whether a particular court in that matter, just a moment, in that particular case, a court can take the cognizance of the matter or not. So what exactly do we mean by cognizance? We say that cognizance means where a court is empowered to take the note of that particular case. So I was giving you an example of a crime has happened in Gujarat, Gandhinagar district. This is one part. The same type of a crime has happened somewhere in Bombay, Maharashtra. The same type of a crime has happened in Delhi. Now, the question is that whether the similar type of a crime, and hypothetically, the person remains the same. So, say suppose my client is there in Delhi, Mumbai, and Gandhinagar. Every time he is a victim of the same type of a crime. So, whether it can be taken, whether this case can be noted by Gandhinagar court, by Bombay court, or by Delhi court, this is called as jurisdiction. In that case, we have to keep into mind that wherever this person is, wherever he goes, wherever he is interested to file a case or file a complaint, he can do it. But this is not so in the cases of the cyberspace. So we find that the concept of fourth space or the fourth dimension to a particular thing is something which requires the principles of the jurisdiction to be there. My slide has changed. Everybody is able to see this? The change of slide?
Yes, ma'am, cyber
Okay,
jurisdiction.
fine. Cyber jurisdiction. So the problem is that when I say a crime happens in Gandhinagar and a crime happens in Bombay, you can understand that my client has to go to Bombay, or my client has to get the complaint done in Gandhinagar. But is it the same case when it happens to be in cases of cyber jurisdiction? So this is the question that comes to us for the deliberation, that it is not the same case, or it is not the similar on the similar line. So when we talk about the cyber jurisdiction as far as the national jurisdiction is concerned, the nation or the state or that particular country can take the jurisdiction where the domestic legislation grants jurisdiction to the courts within the country, which means that you have a law, and that law say that you are empowered enough to take the cognizance of the matter. Second, if it is considered as a national crime, so it must be defined in the law of crimes that yes, this is a type of crime which is happening where a particular court can take the cognizance of the matter. Where we find that the offenses under IT Act, the all the offenses which are mentioned, so there may be a possibility where I am talking about a crime related to cryptocurrency. So, for the audience to know, cryptocurrency related crimes are not being there in the ITA. We are not, we don't know whether such type of a crime exists as far as ITA is concerned. So, in that case, our courts are not being empowered to take the cognizance of such matter. So, in cases when we are talking about transnational, so there is a term which we commonly use as international, and there is another thing which is called as transnational. So once I am talking about a few countries in question, so say suppose if I am talking about SARC nations, if I am talking about the Asian countries only, it will be transnational. But if I am talking about more countries at hand, if I am talking about 20 countries at hand, or when I am saying that it is a global issue, then I am talking about international jurisdiction. So transnational jurisdiction is where the crime involve more than one country, and more or less the cyber crimes are having the nature of transnational, as when we find that there are a particular type of a crime are more active. Like if you might be knowing this fact, that salami attacks, or the examples of draining out the saving accounts is more common when we see that the attackers are from Nigeria, correct? Website hacking, more common from the southern African countries. International, we see that international crime is cyber crimes are those type of crimes which is affecting all of us, irrespective of that we are talking about a group of countries. So for an example, if I'll say cyber terrorism, I love you virus, which was there launched, and everybody was very much afraid of what happens to this bug if it enters to the email, because it operates on a very simple thing, that there was a envelope sent through the email attached as an attachment, which says that I love you. And if you open it, if you open it in your system, the malware will get into your system, and it will destroy the entire files which was there. So in fact, this is something which has got the international impact of the crime, which is not targeted only in Asian countries or only in India or in Africa, but it was targeted throughout the world. So this type of crimes are cyber crimes, which are coming under the category of the international crimes. So what happens in case that the different type of crime happens, and how do we decide, or what are the basic tests to decide about the jurisdiction? So we have to understand that whether uh, there are something which is posted on the worldwide audience, or to the worldwide forum. Second, whether it is easy for us to remove the material from one territory or the other territory. We find that the website is hosted in one area, but as directed there are users at the another geographical location as well. Parts of website may be hosted in one area, while where the other part of the website are hosted in another location. And there is a possibility where you will find that it is very difficult for you to determine whether at which point of the globe the website has been located. Now I would like to cite you one case which the Supreme Court has decided in 2012, that is Shreya Singhal versus Union of India. I hope a couple of you must be aware of that case. The case involves section 66A of the ITA, that suggested that anything which is incriminatory, defamatory, annoying, insulting for someone uh, corresponded from one electronic device to another electronic device need to be protected, checked, and such a person will be put to the punishment. Now, in that case, the issue was not only related to that particular section, but also was written in relation to section 79 of the ITA, that talks about ISP, which is the Internet Service Provider. Now, the matter which was incriminating was posted on Facebook. As you know, Facebook is not limited to India only. It has got a worldwide audience. Supreme Court instructed the website, the respective company, that you are supposed to remove the material which is held to be incriminating. Now it has been reported, it has been answered to the Supreme Court, that this is something which is beyond the control of the people who are hosting that website, because the material is available at what end, who can access it, or who all are accessing it, or who have downloaded that, who have saved it. That data is not with the main company or the website provider, or for that sake Google answered this question and stated, sir, we have no idea who all are using at what end. So this becomes a very very difficult situation when we are talking about the jurisdiction to determine. Otherwise, whom are we targeting, whom are we instructing that they are supposed to controlling, or they are supposed to remove this material, because you do not have the jurisdiction also sometime. So we see that there are certain theories of jurisdiction. Now I must inform all of you that this is academic division. This is not exactly which is being by law that we have created, but this is what we have understood by means of different cases. So first is subjective territoriality, which means that if we look for the state where this particular crime has happened, to say that whether you have the subjective territoriality or not, which means whether your law permit you to take the action in that regard. Second is the effect jurisdiction or objective territoriality, which means that, say, suppose if we are talking about an action which is happening in India, but it may have an effect somewhere else as well. So, say, suppose if I'm talking about the activity which is happening for draining out money from private bank for all the bank account holders, you never know whether there are people from Russia, people from America, people from Australia also having their accounts being drained in India. So that is what is objective territoriality. Then the nationality. So the nationality part is concerned, we say that the national law or the national provisions should permit us to tackle that particular aspect. So jurisdiction should be national when you will find that the law is approving of your action in that particular national. But at the same point of time, we find that there is passive nationality principle as well as the protective principle. Now, what is the passive nationality? Kirti, my slides are changing.
Yes, ma'am, there.
Fine. So, passive nationality is what we are talking about, the nationality of a victim. So, say, suppose if I stated to you that my client is sitting in Calcutta and he find that he is a victim of a cyber fraud. But by chance, his nationality is Japanese. So, in that case, the passive nationality jurisdiction rule would permit Japan to take cognizance of this matter and they can try this case. Whereas when we talk about the protective principle, we say that it is where the sovereign is sovereign means sovereign is the state, means the government, the highest order in that particular place or that nation. So the sovereign can punish actions to those who are committed at other places because solely because the people feel threatened. And we find that usually protective principle has been adopted in all the cases where the nations feel like, I feel that when Indians are being attacked or Japanese are being attacked in India, Japan has a right to act upon it. Or when many Indians are being attacked in Japan, Indians should take it. This is protective principle which we are talking. And there are universality principle, which means that looking to the gravity of offense, uh, we are not constraining or we are not delimiting the jurisdiction to only one state, which means that if all of us are affected by I love you bug and I came to know that the malware has been instituted from Pakistan, then I we all can take action against the state of Pakistan or those people who were initiated from it. So I would like to ask from the audience, if any one of you can give me and a simple questions answer, that which is the country or which is the place that is regarded as the first place or the origin place for the viruses which are computer viruses being generated. Any of you know which country is being regarded as the motherland for the first ever computer virus that is created?
Ma'am, I don't have the preliminary knowledge about it, but when I searched it, it is showing brain computer virus, which was originated in Pakistan.
Yes, exactly. It's Pakistan only. There were two brothers who were engineers, and they did it purposefully. So it is not that it is by accident that it is created. Sometimes, many things have been created by accident, but it is on record, which suggested that the first ever known virus, which has I mean, virus is a software only. We all know about it, and it has different potentials, right? But it was purposefully created by those two engineer brothers, and it has actually devastated a lot of things in a lot of computer system, and people were very scared of, because that point of time when we are talking of, nobody was aware of what is a virus. So yes, you are absolutely correct. So now let us talk about what is the position in US. See, this is a question which comes mostly in our mind, that why do we always make a comparison with US? See, I must tell you, uh, apart from being the developed country, apart from being the country which is also having the position of a superpower in the world, we find that the US is a country which is having a larger number of uh, 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 issues raised when it comes to the cyberspace, because they are more advanced in their aspect. Secondly, we discuss them because they have framed laws much in advance than the other common law countries. So in fact, US position is always to be discussed because they are much ahead to us in the technology and the law as well. So the precedent or the law that is created in US is also followed in most of the law common law countries, including India. So what happens in US is that US believes in the principle of nexus or minimum contacts, which means that the physical presence in that particular jurisdiction will give them this authority, that wherever that country, wherever that victim is, that country can take up the call for the cause of action to be there. So we find that it is talking about arm length principle. So you can see that it is talking about long arm, due process. But in ordinary senses, where we discuss about what is the principle that is being followed in America or United States, is arm length principle. So arm length principle means what? Wherever the affected party is or wherever the victim is, so irrespective of the fact whether the thing has started in Nigeria, in Pakistan, in India, or any other country, the American law will have a prominence for jurisdiction issue if the maximum number of affected party is American. So they follow the this principle, where you will find that the understanding is very clear as to that this particular uh, country can take the law in their hand. Now second aspect is that what are the principles where the United States Supreme Court has taken to interpret. There are many cases like minimum contact test, international shoe versus Washington. I'll try to discuss a few of them. Reasonable anticipation rule has been also followed in worldwide Volkswagen Corporation versus Woodson case of 1980. And I must tell you that there are so many new cases are coming every day, but these are the cases which has established the very principle of jurisdiction in America. Similarly, you will find that there are other laws as well. There are other provisions also in place which is talking about virtual presence challenge to territoriality, where we find that UN Citral model is there on e-commerce, which is adopted in 1996 by the General Assembly, where you will find that all the states will have a jurisdiction to try for those matters which is affecting them. So you will find that the law as such is talking about not the international jurisdiction but the local jurisdiction. So say suppose if I am India is the most affected party for a particular type of a crime, Indian jurisdiction can take a lead in these matters. We will find we usually see that USA is having a principle which is based on two set of principle, whether there is any statutory basis which gives the plaintiff an opportunity to sue the defendant, because whether your law give you the opportunity to sue. Second, whether by any act of business the defendant might have a reasonable assumption that he might be sued there, which means that whether during making of a contract or making a particular thing into a reality, whether you agree that the American laws are going to apply or Indian laws are going to apply, or which country are we aiming at, that law is going to prevail. So we will find that in fact the specific jurisdiction, which means that whether we are talking about the US law, Indian law, which law, it depends on the factors which are called as minimum contact, fair play, and substantial justice. See, uh, these things, although they are academic in nature, but they are based on case laws. So this thing, this understanding, this information is definitely going to help you to solve the cases of people, those who come to you. Or you can also be aware of that fact that, say, suppose if it is something which is what is being more fair, because I am the affected party and I am in Indonesia, Indonesian laws should be followed, or it is something which is going to give me the substantial justice. So let us take about one of the case, which is the case of America, Zippo Magnifying Corporation versus Zippo.com Inc. It was decided in 1997. The the court has to take action on the nature and quality of the commercial that a company took on the internet to determine the jurisdiction. You will find that the websites which are being actually hosted by a particular national company, they are actually copied. And in fact, the websites which are not in the same jurisdiction are showing the same material. So you find that they have got three different categories of the website. As you can see that it is more related to the domain name, like zippo.com, zippo.net, and zipponews.com. Similar type of cases also happened in India, which is for India TV. And this is a case of America. We had it India TV, and India TV live news.com was created by someone who was sitting in America. So on the same line, the Indian courts have also taken a cognizance of the same matter. As in this case, the American courts have taken a cognizance of it. Second case that is very much discussed is something in relation to Yahoo Inc. versus La Ligue contre Li Sim, where you will find that there was a Yahoo internet service provider which was originally from America. They have found that a French company has created a Yahoo France. This is actually that what I have read it in the French. It is written actually in English, but that was somewhere in the France. So the issue is that whether the Constitution and the laws of United States will regulate the speech in some other country, whether something that is registered in America. I have given you an example of India TV. So you know that India TV is a very well reputed news channel in India. And if someone is going to put indiatv.com in America, definitely if a person from India or a person who knows that India TV is there in India, he will consider that, okay, this might be the same company, or this might be the extension or the subsidiary of indiatv.com. So in fact, such type of things have happened, and the court has held, this went to the Supreme Court, and court has held that the French order is valid under the laws of France. It may be enforced with the retroactive penalties, and that was going the possibilities of in the United States as well. See, Yahoo.com is a registered company in India, in America. Similarly, if you create the similar type of name, you are taking not only the violation of the domain name, you are also taking care of the goodwill which is created in the American system. So the courts have regarded that this is not where we will accept it, and the penalties were imposed. And the court, American courts have applied arm length principle and have instructed that to the other jurisdiction for stopping the material which was posted in Yahoo Inc. And they have also stopped the French company or the French online company to show the material which was originally coming from the American company. Kirti, the slides are visible.
Yes, ma'am, there.
Okay. So cyber jurisdiction in India is all about ITA, which is in the Information and Technology Act. We do not actually speaks about any principle. We follow that the we are not speaking vocally on the issue of jurisdiction, but we find that there are two type of situation can arise. Number one, where we have the decree or the order from a foreign court, or we find that how the foreign courts are assuming the jurisdiction in the internet related matters. So we find that the section number 1 subsection 2 talks about the jurisdiction of ITA throughout the country, and also wherever the offense or contravention is made by any person outside the country. So we find that basically the jurisdiction is not defined in ITA directly, but it deals with prescriptive jurisdiction. So what is the understanding of being prescriptive? Is that we are talking about that if the jurisdiction lies to Indian court where an offense has been committed even outside India by by a person for a computer system or computer network located in India. What is the understanding? The understanding is very clear. If any substance which is used in a crime is Indian by any person who is Indian on any person which is Indian, we will have a jurisdiction to try that case. An example has been written in the slide. Please read it. Similarly, Section 75 of the ITA, it provide for the extraterritorial jurisdiction. It gives jurisdiction over foreign subjects as well. As I stated to you, there can be three situations. One, the subject over which any fraud, crime, any issue, civil infringement happened is Indian. Number two, that the network, system, etc. has been used is Indian. Number three, at any place of the globe, anything has happened in relation to cyber space is done by an Indian. It's a crime committed by an Indian. Subject is Indian, the object is Indian, and affected party, victim is Indian, we will have a prospective jurisdiction. So we will find Section 75 being giving us a extraterritorial jurisdiction. In fact, the ITA is clear about it. Similarly, when we talk about civil law jurisdiction, this civil law is basically talking about pecuniary jurisdiction, subject matter jurisdiction, and territorial jurisdiction. What do we mean by pecuniary? Pecuniary is the penalty, fine, amount of fine that is imposed as a monetary penalty. Subject matter, whatever is the subject matter to that particular issue, contract, the goods that are being purchased, the goods that are assembled, the goods that are delivered. Territorial jurisdiction, whether we are talking about Indian jurisdiction, American jurisdiction, or wherever the contract has been signed. So civil jurisdiction in India is actually a subject matter of CPC, whereas the CPC is talking about both the type of property, whether it is immovable or the movable property. Section 16 and Section 17 and Section 18 of CPC is discussing about the dispute in related to the I'm sorry, these are the sections which are discussing in ITA that talks about whether there is a dispute related to any immovable property, and what are the dispute related to the jurisdiction, where there are more than two defendants. Section 20 is talking about what will be the cause of action when the jurisdiction will be in those matters where the defendant actually reside or carry on its business. In nutshell, what we are talking about is that in every respect we have to consider at what place the contract is completed, at what place the parties are residing or the victim is residing, accused is residing. These are the things that we have to take care. Criminal law jurisprudence is based on two basic laws, IPC and CRPC. So section 3 and 4 of IPC also deal with the extraterritorial. Now understand what is extraterritorial jurisdiction. Territoriality means my law will be applicable only in my country. But suppose if my law is applicable in your country as well, this is called as extraterritoriality. But extraterritorial means does not means that Indian law will be applicable in America. No, Indian law will follow the people in America, either if they are Indians or if the victim is Indian. So, in both the cases, the territoriality of IPC remains with the Indians only. But if a computer system is used which is from India, if there is something which is a person is there who has used Indian system, so that way it will be called as the Indian penal. It will be the Indian Penal Code. Section 177 and 178 of CRPC is talking about any offense which need to be inquired in a court which is Indian, and 178 where we find that how many different types of the acts are there, the jurisdiction will be there or not. So similarly, section 179, 180 of the CRPC will discuss about it, and these are the principles of courts taking the cognizance of the matter. So we find that the primary theory of territoriality is given under section 177 of the CRPC, which provides that every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it is being committed. So, if the crime is through cyber crimes, it will be definitely taken care by the Indian laws only. So, we find that subjective territoriality rule or the objective territoriality rule. So, where we are looking forward for a situation which has initiated in one territory but it has been completed abroad, we find that this has been initiated but actually completed somewhere else. So both the territories can take the cognizance of the matter. Whereas we provide that the objective and subjective territoriality concept is providing the right to the courts to take the cognizance of the matter. It is for the betterment of people who feel affected, that my agony, my pain is not been answered through the law. So we find that the effects principle is the most important principle that we follow. Who is being affected the most? So I'll say, sir, this particular thing is initiated in Nigeria through Australia, uh, 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 two people who were sitting in Uganda. But in fact, the Indians are the one which are having the most effect of it. So yes, Indian laws can take over these matters, or we can also try the matter. So for an example, this is the case of SMC Pneumatics Private Limited versus Jogesh Kavatras, which is the first of its own type in India, where in defamation, the defamation has happened of the corporate body. It has been held by the Delhi High Court that the corporate reputation has been defamed. They have passed an ex parte injunction. Ex parte means when the other party is not present, but still they have passed it. So it is because the law or the court wanted to show that although there is no provision of law, but we in India, the corporate body in India is affected the most. So we have the authority to pass the law. So in this matter again, the case which is relied is that of section 179 of CRPC, which is talking about the case where state of Madhya Pradesh versus Suresh Kaushal, the court, Supreme Court, I mean, the apex court has discussed about the importance of having the jurisdiction, where we have also applied the same principle in the case of cyberspace, where we have mentioned that during because of the uniqueness of www world wide web, we find that it is something which is permitting the crime to be faceless, territoriality less, and to find it very difficult for the trial as well. So we have to at least go at some place deciding that no, we have the jurisdiction to try the matter. Similarly, in this case, we are talking about Sony.samban.com case, where the we have seen that non-resident Indians were being targeted, and at this point of time, the courts have taken the cognizance of the matter and have held that no, we will try this case because it is our name that has been taken. So this is where you see that the credit card was being used, and the crime was actually committed by somewhere other than this. So in nutshell, when we talk about the uh, uh, the matters which is related to the jurisdiction, the matter is absolutely clear. If the affected party, or if the laws do permit us, we can try the case. So this is in a very short, since this topic is very big, we take more than 3 months to cover as a part of our regular syllabus, and there are so many things which we have to discuss through the case laws. I tried my level best to help you out with the basic understanding of the topic, and I will appreciate if there will be questions for this particular topic.
A very warm thank you, ma'am, for this informative session. I must say, the way you explain the concept of jurisdiction in cyber law so clearly that it made complex topics of Indian laws too easy to understand. Thank you for this, ma'am.
Thank you.
Uh, Participants, it's time for the Q&A session. So I kindly request you to please drop your questions in the chat box. Ma'am, can we allow participants to raise the hand and ask the
Yeah,
question?
yeah, bilkul, bilkul, absolutely. I have no problem.
Participants, you can also raise hands.
Yes, Kirti, please ask me a question.
Yes, ma'am. I have a question that is there any relation between Data Protection Act and cybercrime? Like, are they
Data protection
Data Protection Act,
and is there any?
cybercrime?
Acha, is there any? Acha, okay. See, DPDPA, when we talk about DPDPA 2023, it is only discussing about the protection of your data which you have given to someone. Like the DPDPA is talking about one person who is the fiduciary body, and one person who is actually providing the details. Like I am giving my information to Vodafone company. Vodafone company as a service provider is a data fiduciary, so it should not pass on my data to any other person without my permission. This is what is data protection. It actually does not speaks about anything in relation to cyber crimes per se, because for data, and for which type of data are we discussing, we also have the Aadhaar Act into place, because mostly we are talking about the biometric data. So, as far as that aspect is concerned, we are clear. DPDPA is not talking anything in relation to any type of a crime or any type of jurisdiction issues. It's very clear that we are empowered enough to take care of matters related to data breach.
And ma'am, what do you think should we approach in the upcoming years to be more like cybercrime aware? Like people are not very aware now.
Right. Actually, the whole idea is, what I understand is that most of us become victim. Although we discuss a lot, we create a lot of awareness, etc., etc. But why we become victim is because of two things. Number one, that we believe other. The we transaction is mostly on the basis of faith. That I believe you, I believe Kirti, I Kirti believe Anjani. So I can betray that thing. So one thing is faith and belief. Second thing is greed. So once I inform you, Kirti, you have got a lottery ticket, and you have. Please give me the details as to where do you study, what do you do, where do you live, and you start giving me that because you got a lottery. So the two things has to be very carefully dealt with. I'm not saying you should not believe anyone, but don't share your confidential information about things. Don't post too many things on social media platforms so that I can make it up. Okay, Kirti is very affectionate to her pet. Her pet must be something which is very very dear to her, so her name or his name should be the code word, should be the pin and all. So we make ourselves available by posing faith on another. So I think this can prevent, otherwise it's very difficult for you to make people say you should read about cyber crimes, you should read, you should listen about cybercrime and being not affected by it. It's very difficult, very difficult.
And ma'am, do you think do we need any statutory provision for cybercrime?
We do need it, and that is why I must say that all these questions, like what we were discussing about data privacy violations or the data breach, etc., it has been actually covered in the Digital India Act. So I, as a student of law, I am hoping that the Digital India Act will be a reality soon. It is covering IPR issues, it is covering jurisdiction issues, everything has been answered there. So as soon as this act will be a reality, I think we will be better as far as law is concerned. So there is Amar who has raised his
Yeah,
hand.
good evening, ma'am. I
Good
have a
evening.
question. Like, if Indian companies are working in the foreign sites, like in other countries, and there's a data breach of data happens, in that case, the jurisdiction will be from that country or our country.
See, if you are working for another company which is working in other jurisdiction, say suppose I hypothetically say it is an Indian company which is working in Japan, then Indian laws will prevail. But if it is a Japanese company working in Japan, Japanese law will prevail.
If vice versa, like Japan company working in India, in that case, ma'am,
Then Indian laws will prevail. We follow a very simple principle of lex loci. Lex loci is local law. So if you are in India, if you are a Japanese company registered in India, incorporated in India, Indian laws will prevail.
okay. Thank you, ma'am. Have a nice day.
Ma'am,
Ma'am,
if
there are some questions in the chat box.
Please ask me.
Uh, One is from Neha. She's asking, what should we do if we find our email on dark web?
Okay. See, as far as dark web is concerned, you will not be surprised if I'll tell you that there are so many websites which are on the dark web, which are sharing information from people like you, me, and people who are not very significantly known as celebrities, or which are not very commonly followed for. So we don't have to bother too much. It isn't that we are supposed to go and change our mail id. It is better that you can make all those who are known to you aware of the fact that any information reaching out from this mail id should be cautiously dealt with, because I have seen this email id on a dark net or a dark website, where I find that they might use it for some other purpose. So in case if there is a demand for money, if there is any threatening email reaching out to you, you please verify it from me. Because if you keep on changing the email ids, what will happen, this tendency will keep on increasing. People will again and again and again use, you are leaving that email id because you can't stop it if there is another person who is using it. So there are websites which are collecting your information and posting and selling it out to many such people. So I would suggest, don't be scared of. The only thing is that give minimal attention, minimal information to them. Pay attention to whom all are attached with you, and give them this information that they should be carefully dealing with this email ID.
All right, ma'am. Ma'am, the next question is, what are onion sites?
What is
What are onion sites?
onion sites? Oh, actually this is nothing which is a term that is used for dark net. Actually see, I must tell you what exactly is a dark net. ये कोई ऐसा नहीं होता है कि कहीं गोरा नेट है, कहीं काला नेट है, ऐसा कुछ नहीं होता. There's not a bright net or a dark net. See, what happens is, it is difficult for sometimes, say suppose if I am emailing to you, suppose मैंने आदित्य को कोई mail किया, कीर्ति को I have mailed or I have messaged something from using my system, and they wanted to assure कि अंजनी मैडम ने ही किया है, so they can trace it back to my IP address, correct? This is a very straightforward way of getting the information. But say suppose if I am on a dark website or a dark net, they will have to go peeling up like a onion. They will not be able to find out my IP address. My IP address will sometimes show from Singapore. At another stage, it will show from Canada, third from Nigeria, then Uganda, then Australia, then falana, falana, but never India. But actually, I am in India only. So the onion sites are those sites where you have, these are the layers of hiding the true identity of a person is created. That is known as the onion sites, and this is just on the lines of being, peeling off the onion, and we never come to know, because we are not aware na, ki how big is this onion. So it is difficult for us to find it out. That's it. Yes.
Ma'am, the next question is about the DNS.
BNS.
Yes, not ma'am. Not DNS, it's DNS.
Okay.
Private DNS.
Okay. Please ask me. Private DNS which is created.
Yes, ma'am.
Okay. Is there any specific thing which has been asked, or what is it?
Ma'am, it's just what is private DNS?
Okay. See, actually, what happens is that in order to have a unique identity, or what we say, that say, suppose this is not possible for a common man to get, right? It might be shown in the dramas or movies or other platforms, but it is only possible where the government agencies are involved, or where we find that the big body corporates are involved, which are dealing with something which is highly confidential. So in fact, when we talk about such type of a private or some information or some IP address which is not publicly known, or it is not publicly available, it is available, or it is being a confidential part of a unit or a corporate, a body corporate, which is called as the private DNS. And you will find that it is only permitted through government. Not a single country is there where you will find that private people like me can get it. We have to take through the government's permission. That, and of course, terrorist organizations I'm not discussing for, because anything which is beyond law is not to be bothered for or to be discussed for, because they can do anything. We are not into it, but otherwise, legally speaking, it can only be done through the permission of the controlling power at the democratic end or at the government, not otherwise.
All right, ma'am. The next question is from Aswini. Uh, he is asking for the digital arrest. What do you mean by digital arrest?
Digital.
Arrest.
Oh,
Digital arrest.
okay. Acha. Okay. Digital arrest. See, in fact, the digital arrest, actually, what I understand is, has been a byproduct of BNSS, Bharatiya Nagrik Suraksha Sanhita 2023, which has made the audio visual trial a reality, which has made that the warrant and summons can be sent electronically. But believe me, none of the provisions of BNSS is talking about arrest warrant being electronically sent. The warrant and summons are for various purposes, right? So say suppose if my client is a witness, and he has to appear in a consumer protection matter or a consumer related issue, he can be given a summon. My client is related in a family matter, so for that also a summon and a warrant can be issued electronically. Believe me, nothing exists in India which is called as digital arrest, because we do not issue any arrest warrant digitally. Still, even in BNSS, we have to have a document of the arrest warrant, and it is issued with the seal and signature of the court. It is issued with the name of the police officer who will execute it. So digital arrest jaisa kuch bhi nahi hai. This is all a misunderstanding, and this is all because whenever we find that there is an issue related to government and us, जैसे government and us, ये मैंने helmet नहीं पहना and I am driving a two wheeler, मैंने belt नहीं लगाया and I am driving a four wheeler. तो if someone comes to me and say that madam आपका चालान होगा, I immediately start negotiating. अरे भैया जाने दो ना, 50 रुपए ले लो ना, 100 रुपए ले लो ना. So what happens in digital arrest also? People when informed that you are under digital arrest, they started negotiating. नहीं नहीं हमारा नाम खराब नहीं होना चाहिए, आप बताओ ना हम कैसे कर सकते हैं, कैसे आप हमको इससे बाहर निकाल सकते हो. So in India we still have physical arrest, we still have the arrest warrant being issued physically by the court, and no digital arrest has been permitted.
All right, ma'am. Thank you for the solution. There is one more query. It's from the Yaswini. She's saying, ma'am, if the alleged person of a cybercrime issue is from a country, but the maximum affected people are from India, can alleged person be extradited
Extradited.
extradited to Indian in this case?
He can be, provided that we are having extradition treaty with that particular nation. In such ways what happens is that we have a trial in absentia in India, and we pass on this order, whatever is the judgment, we pass on this judgment through section 166b of the execution in case of CRPC. We send it across to that country asking that, sir, this is our decision, this is our trial, we would wish that this person be extradited to India. If not, please execute this particular judgment in your jurisdiction. So that is how we do it. Ordinarily we have to have the extradition treaty.
All right, ma'am. Ma'am, one query is from my side. Ma'am, I recently encountered a cyber-related issue where my friend received an email claiming from the cyber cell Bangalore, and
Okay.
it was very hard to determine that it's
Fake one.
actual it's a notification or not. So, ma'am, actually, my question is, how can we effectively verify such things it's fraud or not?
The what type of a summon or a notice has been issued?
The issue was for actually it's an arrest issue,
Arrest issue.
arrest warrant.
Okay. They see, Aditya, now the law is section 35 subsection 3, right? I'll repeat. Section 35 subsection 3 of BNSS requires that before making any arrest, the police officer, the IO, in investigation officer in that matter, should give a notice in writing to call that person. And for your information, BNSS is also prescribing for a format of the notice. It should carry the phone number of the IO, it should carry the name of the IO and his seal and signature. So how will you determine it that it is correct or not? By calling it back to the same person, right? And suppose that this particular thing, hypothetically I'm saying that your friend is in Gandhinagar and he receives it from Bangalore, correct?
Yeah.
Then the law is very simple. The Bangalore person cannot come and talk to your friend in Gandhinagar. He has to come through a person, through a equivalent position holder in Gandhinagar police, which
Yes, ma'am.
means if he is coming from Karnataka police, he has to execute the summons of section 35(3) BNSS through a equivalent officer of Gujarat police. So the veracity of that thing can be found out by calling that person or by looking to the fact that whether this person do exist or not. The best way is that if you can call him or you can talk to him one to one and tell him that, sir, this has not been executed, and give the objection being raised at there and there only, that you are not executing it through my local police personnel. How could I believe that it is correct?
Sure.
So that is how you can do it.
Thank you, ma'am. Ma'am, next one is Amar. He is raising his hand.
Yes, Mr. Ramar, please ask me.
Ma'am, I want to know how is jurisdiction handled in cases involving blockchain or decentralized platforms like fiat currencies or cryptocurrencies.
Okay.
In those matter how jurisdiction is
Okay.
determined.
So to be very honest, Indian government has neither accepted cryptocurrencies nor denied it, which means that say suppose unless that particular thing or that incidence is not coming under cyber fraud, Indian jurisdiction does not have any say into it. So unless I'll say that this is a situation where I will say that something which is of a nature, like for an example, what type of an example I should give you. It is something that plastic money. So plastic money, sir, it is operated, you would be you may be aware of the fact that there are some cults, including the Dera Sacha Soda cult, coming from Haryana, where these type of people are having their own currency. You'll not be surprised if I'll tell you that while investigation the matters of the Dera Sacha Soda, it was disclosed, it was discovered that they are also having their own currency, means operative only in their jurisdiction, in their circumference. Now the problem is that Indian government is neither accepting that there is a cyber currency or cryptocurrency, nor it is denying it. So, say,
But
suppose if someone is sitting outside, using the resources outside, drains out money, cryptocurrency of my client, I will have to prove it that, sir, it has happened through some sort of a IT means. And I would like to request you to please look into this fraud, which is an IT fraud. Otherwise, sir, I'm left with no option but to go and to check it out at what platform was my client cyber cryptocurrency was, and how can I redress, go for his redressal. Yes, sir. You have another question, sir?
yes, yes, ma'am. But the union government in its 2022 budget imposed 30% tax on the income generated from virtual digital assets, and it includes cryptocurrency also. Then,
Sir?
in this way, government recognize cryptocurrency.
Taxation is another issue, sir. Taxation means what? Taxation is the general principle of income tax states that any income that is generated to an Indian, whether in India or outside India, it is a subject matter of taxation in India. Correct, sir? This is the bottom line. This is the principle. Cryptocurrency is accepted in other jurisdictions. It's a valid currency. It is a valid means of earning. So they are not questioning that. Neither they are denying nor they are accepting. They are simply saying, if my client sitting in America is earning, but my client is Indian citizen, Indian resident also, they don't believe in citizenship. Income Tax Act is based on a very simple principle of being resident. So my client is an Indian resident. अभी वो किधर से भी कुछ भी कमाता है, he has to pay taxes in India. That's it. That is the bottom line, sir. It does not mean taxation, paying taxes will not make anything legal. So it is something like that, sir. I would like to
But
explain you, sir,
but
that say suppose if my client is a dacoit, or he's a person who is involved into abduction or kidnapping. So he takes a ransom, ठीक है सर, and he pays the tax. वो कहता है यार मेरे पास 1 करोड़ रुपया आता है रैंसम में, बट आई एम गिविंग यू सर 30%, मैंने आपको 30 लाख रुपए दिया, तो मेरे 70 लाख साफ हो गए. I should be a honest taxpayer, sir. No, it is still wrong. It is still not recognized. So we need to have a law for for the cryptocurrency. That is the understanding.
so only that way the government will recognize after the government enact any law in this regard.
Absolutely, absolutely. Where they'll have to accept it. Yes, this is a means of income. Yes, this is a means of
But
transaction.
maybe directly or indirectly by imposing 30% tax on cryptocurrency transactions, they are recognizing it.
Sir, recognition does not means it is legal or it is having a sound legal understanding. Taxation is something, sir, if I earn by illegal means also, paying taxation would not mean that government recognizes it. Suppose my client is being under scrutiny of Income Tax Act, correct, sir? It was disclosed that 5 saal pehle he was a daku and he has earned something for which he has not paid the tax. So, sir, do you want to say that it will be accepted? कि हाँ डाकू होना अच्छा है? No, it is still something which is questionable. So our understanding is either you accept it that there is a cryptocurrency, we accept it, and it can be a valid means of transaction in India. So I can purchase a car, AC, a tractor by means of cryptocurrency. Or you say no, no, we don't accept it. If you want to risk it, you risk it, your money, we will only take tax on the income generated. अब आप ये भी नहीं कहते हैं, वो भी नहीं कहते हैं, तो मेरे जैसे व्यक्ति के लिए तो थोड़ा सा मुश्किल है सर अंडरस्टैंड करना. It's difficult for me to understand what exactly is the concern or the mood of the government. So fine, Aditya, I think we can close the session. You'll say?
All right, ma'am. This was the last question. And ma'am, with this, our webinar is also concluded. And as we conclude our Cyber Awareness Week, organized by the CyberShield team at Naksh Foundation, we extend our heartfelt gratitude to each of you for your active participation and engagement. And we are deeply thankful to our esteemed speaker for sharing their expertise and enriching session. Thank you, ma'am.
Thank you, Aditya, thank you, Kirti. Bye bye.
Yes, ma'am.
Thank you,
Everyone,
ma'am.
Thank you, ma'am.
please fill the feedback form that is in the chat box, and your certificates will be provided till April 10th with your through your email. All right. Remember, awareness and vigilance are our strongest defense against cybercrime and threats in the today's cyber world. Thank you all for your participation. Stay connected with Nux Foundation and Project CyberShield for more such initiatives. Have a wonderful evening and stay safe online.